estate planning is the process where you manage the distribution of your assets, and also, you provide yourself with options for healthcare decisions in case of your death or incapacity. The benefit of estate planning is that you decide how you want these assets to be handled now and in the future. And you need legal documents to create those. So we've all know what some of those legal documents are. Everybody has heard about a will, right? Everybody's heard about trust and powers of attorney. There are several other documents, and we're going to go into much more detail. So an estate plan essentially requires that you look at all these documents to determine what is best for you. Do you need a will, or do you need a trust? Or do you need either? Because there are other techniques in estate planning where where you can designate beneficiaries on certain assets and avoid probate and really obviate the need for a will or a trust. And we'll talk about those as well. And also, if you have minor children, there are several legal documents you can use, principally the Declaration of Guardian for Minor Children. And also, if you get in a position where you're terminal or you're about to meet our maker, you can dictate how you want to be handled at the end of your life, right? There's something called advance directives. You also, if you're going to get in a situation where you can no longer make financial or medical decisions for yourself, there's a regular, what we call the Texas Statutory Durable Power of Attorney, and also a separate legal document called a medical power of attorney. So we're going to talk about all these documents today, and then what happens if you die without a will? What happens if you die what they call intestate? And we'll talk about that as well. So in its simplest form, we'll start with the document that everyone recognizes, and we'll talk about a will and the advantages and disadvantages, and we'll talk about trust, the different kinds of trust, and the advantages and disadvantages of it. So a will, as we all know, is a legal document, right? That you say, when I die, this happens, right? And if you have minor children, you can designate in your will who you want a guardian for your minor children. However, there are legal requirements for a will to be effective. And also, I want to make clear, a will has to be probated, and we'll talk about what that means, but basically it has to be legalized, it has to be proved up. If you have a will and the person never takes the will to probate court, it has no legal effect because it hasn't been legalized, it hasn't been probated. So everyone knows a will must be in writing. You can't just verbally say it. It must be in writing. Now, Texas law does allow for you to do a handwritten will, but it has to be solely in your handwriting. You can't have anything typed. It's called a holographic will. The challenges with handwritten wills is how do you prove that is your, that was the decedent's handwriting, that was what the person wanted. You're probably going to have witnesses. You're going to have to go to probate court and prove up a handwritten will. I mean, you can do it, but it has to be entirely in that person's handwriting, okay? So most attorneys recommend do the formal will, where you have it typed up, go to an attorney, and you meet all the legal requirements for what they call a formally attested will, right? So what are the requirements for a will in Texas? Obviously, you have to have what they call capacity. You have to be 18 years old, or if you're under 18 years old, married or in the military. You have to have testamentary capacity, basically legal term that says you know your assets, you know what you're doing, and you know who you want to give them to, right? That's called testamentary capacity. And then, of course, your intent. Who do you want to get these assets when you die? And these assets only are distributed when you pass away. So those are the requirements. Now, to do a formally attested will, what we do in our office is we have two witnesses that are disinterested, not heirs, right? And then we do a ceremony. We go over the will with the person, what we call the testator. And then we do what's called a self-proving affidavit. A self-proving affidavit is a little addition to the will that is signed by the testator, the person who is signing the will, the two witnesses. And basically it says, we, the testator, and these two witnesses, we're here. The testator signed the will in front of us, indicated this is what he wanted. We all have the legal capacity. And that helps because when you take the will to court, you've already met the legal requirements to probate a will. So when you go probate a will and you have that self-proven affidavit, it's pretty easy to probate a will at that point, assuming no one contests the will was done properly, and that's why you do that. So that's the nutshell of a will, right? You want to go to an attorney. If you're going to do the will, you want to have it signed in front of two witnesses, in front of a notary there with the attorney, and after you pass away, then the will needs to be probated to have legal effect. So if you go to page 2 of my handout, what are some advantages of a will? Well, obviously, you get to dictate who gets your property when you die, and you get to pretty much avoid disputes over who gets your property. Disadvantages, and this is a significant one, you can incur legal fees that are significant in probating a will. Let's say right now the average cost to prepare a will with an attorney, depending on the complexity of your situation, can range from as low as $500 to $1,000 or $1,500 just to do the will. Then to probate a will, depends, because there are some expedited procedures. But let's say you probate a typical will, it can go anywhere from $1,500, $2,000, $3,000. For more complicated estates, it can run past $5,000 to $10,000. Just depends on your personal situation, right? So that's one of the significant disadvantages. That's why a lot of people don't want to avoid probate, because probate can get expensive. And also, if you probate a will, there's a time factor. Your beneficiaries may have to wait to get the assets and get their money, because the way estate administration works, the will is presented to the court blesses the will, admits the will to probate, then and then follows up your wishes as to who is the independent executor of your estate, and they're given what they call letters testamentary, which gives the executor the power then to act on your behalf after your pass, to collect the assets, pay off the debts, and distribute the assets to the beneficiaries in your will. And that can take time, right? And there's an accounting that has to be done. So another document, legal document then, if folks want to avoid probate or in combination with a will, is a trust. So what is a trust? A trust is basically a legal arrangement where a grantor or trustor or settler, the person creating the trust, transfers property to a trustee who then manages the assets for the benefit of beneficiaries. So there's three parts: the trustor or settler, the trustee, and the beneficiary. All right? So, and the document used to create a trust, it's called either a trust agreement, trust instrument, or declaration of trust. But then you also have to fund the trust. That means you have to transfer property to the trust. So if you're transferring real property, you do a deed from you to the trustee of the trust, because a trust holds legal title in the name of the trustee. So for example, I want to create the Salvador Espino Revocable Living Trust. My wife and I, Salvador Espino and Elizabeth Espino, then transfer property to Salvador Espino, trustee of the Salvador Espino Living Revocable Trust. That's how you transfer real property. Then if you want to transfer other things to a trust that's living, then you'd have to go to your bank, change all those names to the name of the trustee, not you in your individual capacity. So everyone's heard of living trust. What is a living trust, revocable living trust? That's where you maintain control of the trust. You can be the settler, the person creating the trust. You can be the trustee of the trust. And during your lifetime, you can revoke it if you want. But upon your death, the property is then distributed to the beneficiaries the way you want in the trust agreement. And that's what they call a living trust. So why do people do that? The number one advantage is you don't have to go to probate. But there are legal fees to set up a trust. That's a disadvantage. And up front, depending on how complex your trust is, most attorneys can charge from $1,000 to $2,000 to create a trust. And then you have to do the deed to transfer property to the trust, right? So there's a cost there. And then with a trust, you control, if the trust has income, who gets those distributions, the income from the trust. And also, the disadvantages, there's ongoing administration expenses. You probably have to go to an attorney if you want to make changes to the trust. And then if somehow you forget to transfer an asset to the trust, then it goes through the probate process. Let's say you forgot to transfer a property that you had somewhere else and you didn't mention it in the trust. Well, then it goes through the probate process. So you have to be real careful how you do a trust. All right, so now let's go to, in case you are either incapacitated or have a disability, or you want someone to act on your behalf, you do what's called power of attorney. Now, Texas law requires a separate medical power of attorney as opposed from a financial power of attorney. Here in Texas, what I call the financial power of attorney is called the durable power of attorney, and you can make those effective immediately. And the way that works, I, Salvador Espino, appoint my wife, Elizabeth Espino, as my attorney in fact. And Texas has a form that lists all of these different transactions, and I'll pass this form around right now, and you can just see what this form is. So let me just pass it around to everybody. This is called the statutory durable power of attorney. And that's what I call the financial power of attorney. And you can make it effective now, or you can make it effective upon your disability or incapacity. And you will need a certification that you're incapacitated or disabled. So if you're in a coma, you get Alzheimer's, you're in a situation where you can no longer make financial decisions for yourself, if you make it effective upon that, then the doctor certification makes it effective. If you do it like now, it doesn't depend on that. Let's say you're going out of the country. Let's say for whatever reason, you're going to be out of town and you need to sell the real property. You can appoint someone to sign on your behalf to sell real estate, right? That's a regular power of attorney. Now, Texas also has a medical power of attorney. Again, you are always in control of your medical decisions. But if you can no longer make medical decisions for yourself, you can also do a medical power of attorney. I'm going to pass that form around. The statutory durable power of attorney has to be notarized. Now, if you're doing real estate with a regular power of attorney, you have to record it in the real property records of the county where the real property is located, right? If you're going to transfer real estate through a power of attorney. On the medical power of attorney, it can be notarized. If somehow you're in a bind and you don't have access to a notary, it can also be witnessed by 2 witnesses, right? And so you can do a medical power of attorney. And those come in handy. For example, when my father became sick a year ago, he granted medical power of attorney to my sister and I, right? And you can also have alternates. And my mom, 6 years ago, when she got sick, made my sister and I her agents to make medical decisions for her as she became ill. And as we move forward, there's another document. You're getting sick, you're near the end of life. You can do what they call a advanced directive or living will. The formal name in Texas for that document is Directive to Physicians and Family or Surrogates. And I'll just read you, and I'm going to pass this form. This is the 2 things that you need to decide. If in the judgment of my physician, I am suffering with a terminal condition from which I am expected to die within 6 months, even with life-sustaining treatment provided in accordance with prevailing standards of medical care, I either request that all treatments other than those needed to keep me comfortable be discontinued or withheld, and my physician allow me to die as gently as possible, or I request that I be kept alive in this terminal condition using available life-sustaining treatment. And you can't use this in hospice care. There you have to sign a separate document. And also, this is not a do not resuscitate order. You have to do those with your doctor in the hospital. And I guess you can do one outside of the hospital, but you have to have a doctor sign off. And then the other provision is, if in the judgment of my physician, I am suffering with an irreversible condition so that I cannot care for myself or make decisions for myself and expected to die without life-sustaining treatment provided in accordance with prevailing standards of care, I request that all treatments other than those needed to keep me comfortable be discontinued or withheld, and my physician allow me to die as gently as possible, or I request that I be kept alive in this irreversible condition using available life-sustaining equipment. So our family faced this very difficult decision. My mom was suffering from, surprisingly, she had developed fatty liver disease, and she was one of those ladies that didn't like going to the doctor. So she became very sick, was in the hospital for 30 days, and then at the end, she became unconscious, and she was kept alive. You've seen the tracheotomy and all that, machines, and it was very painful for the family, and I might get emotional. It's very difficult to let go of your mother, but we couldn't see her in that condition. So, and she had signed a directive, so she had already made her wishes known, so we told the doctors, don't just let her die naturally, and she came to, and actually when they take you off all these machines, sometimes they don't pass away right away. My mom lasted, this was on a Monday, lasted till Thursday, I believe, when she was lucid, then she went unconscious again, and we were blessed to spend one last night with her. So I'm going to pass this document. It's called the Directive or Living Will, and that is also part of your estate planning. There's another document if you have minor children. Obviously, if you have a surviving spouse and your children are the same marriage, then that person who survives is the one that becomes the guardian of the child, right? And so let's say you don't have a spouse and you're just a single mom or a single dad or a grandparent. Texas law allows you to declare or appoint a guardian for your children in the event of your death or incapacity. Of course, this is your wishes. When you die, there still has to be a court process, right? But courts will honor this declaration of appointment or guardian for your children in the event of your death or incapacity. So I'm going to pass this form around. So we've talked about wills, we've talked about trust, we've talked about powers of attorney, financial and medical, and then we've talked about directives. Does anyone need for me to summarize this in Spanish? ¿Puedo hacer un breve resumen en español? Okay, so now I'm going to say this in Spanish very quickly. Okay, en Texas tenemos la planeación de sus bienes, ¿verdad? Básicamente, ¿a quién quieres designar que sean tus beneficiarios? ¿Cómo quieres disponer de tus bienes cuando algo te pase? Y mientras que estés vivo, ¿Qué quieres que pase si no tienes capacidad legal o si estás en una situación médica donde no puedes hacer decisiones por ti mismo? Entonces se necesitan documentos legales. Hay un testamento. Trust en español es fideicomiso. Trust in Spanish is a very fancy term, fideicomiso. Hay cartas de poder médicas, cartas de poder financieras. Y luego hay lo que le llaman directivos avanzados, donde tú, mientras que estás vivo, determinas cómo es tu cuidado al final de tu vida. Si tienes una condición terminal o irreversible. Y también puedes declarar, mientras que estés vivo, quién va a ser el guardián o quién se va a encargar de tus hijos si mueres o no tienes capacidad. Y también hay ciertas técnicas donde puedes nombrar beneficiarios a tus bienes y evitar el proceso de legalizar un testamento o evitar el uso de un trust. Todos sabemos que es un testamento, es un documento legal, tiene que estar escrito, tienes que tener capacidad legal, 18 años de edad o estar en servicio militar o casado, capacidad testamentaria, tienes que saber lo que tienes, cómo quieres disponer de tu propiedad y a quién se lo quieres dar. Y tienes que tener intento testamentario que al fallecer así te disponen tus bienes. Y luego, Texas sí reconoce que puede hacer un testamento en tu propia mano, pero tiene que dar 100% en tu propia mano y luego se tiene que legalizar en corte. Así que yo como abogado recomiendo, vayan con un abogado si van a hacer un testamento y que se escriba, que tengan 2 testigos, que también hagan una declaración que es atachado, es un anexo al testamento y eso evita testimonio en vivo y es muy fácil legalizar un testamento si usas esa declaración que en inglés le dicen self-proving affidavit, declaración de comprobamiento. Las ventajas de un testamento es tú determinas quién recibe tu propiedad y no hay un desacuerdo entre los beneficiarios y determinas quién recibe qué. Hay gastos, tienes que pagar los gastos de corte, tienes que pagar abogados y si se tarda un tiempo el proceso de legalizar un testamento, puede ser 3, 6, 9 meses, depende de qué tan grande son tus bienes. ¿Y qué es un trust? Un fideicomiso es donde tú, como el otorgador, transfieres propiedad a un albacea o administrador para el uso y beneficio de beneficiarios, ¿verdad? Y necesitas un documento legal que le llaman el instrumento o acuerdo del fideicomiso del trust. Y para transferir bienes raíces al trust, al fideicomiso, necesitas una escritura. Y si tienes otras cuentas, tienes que cambiar las cuentas a nombre del trust. Y el fiduciario, el administrador, el albacea, es la persona que maneja todo esto y toma los bienes en nombre del trust, del fideicomiso. Las ventajas de un fideicomiso, evitas el proceso de ir a corte testamentaria. Tú determinas cuándo se hacen las distribuciones. Y es más fácil transferir propiedad en esa manera cuando tú mueres. Desventajas, un abogado te va a cobrar de $1,000 a $2,000 para crear un fideicomiso, un trust, y luego también las escrituras para cambiar las propiedades de bienes raíces al trust. Y si te olvida un bien y no lo pusiste en el fideicomiso, en el trust, tienes que hacer otra vez el proceso de ir a corte testamentaria, ir a probate court. Todos sabemos que es una carta de poder y en Texas reconoce 2, la financiera y la médica. Texas requiere una carta de poder médica distinta que la carta financiera. Ya pasé ahorita en inglés el formulario de la carta de poder financiera y la carta de poder médica. La carta financiera la puedes hacer efectiva inmediatamente y a veces si tienes que salir fuera del pueblo, vas a vender una propiedad, puedes designar a otra persona que firme por ti. Pero si hay un requisito, si vas a transferir propiedad con una carta de poder, se tiene que registrar la carta de poder financiera en el condado donde está ubicada la propiedad. Y la carta médica de poder es, designas a otra persona cuando ya no tienes tu capacidad legal, te estás en un coma, te pega demencia, tienes Alzheimer's, para que esa persona haga decisiones médicas por ti. Expliqué anteriormente que cuando mi papá y mamá se enfermó, ellos habían designado a mí y a mi hermana como sus agentes de poder para hacer decisiones médicas en caso que ellos ya no podían. ¿Okay? Y la carta financiera también la puede ser efectiva cuando estás incapacitado y se necesita una carta de un doctor para asegurar que ya no tienes la capacidad. Y luego lo que le llaman directivo avanzado, ya estás al final de tu vida, no quieres máquinas y dices, déjenme morir naturalmente. Right? Eso es diferente de una orden de no resucitar. La orden de no resucitar la tienes que conseguir, tiene que firmar un doctor en el hospital o si estás fuera del hospital también un doctor tiene que firmar para que no te resuciten si tu corazón para de latir. ¿Ok? Entonces, también si tienes hijos menores de edad mientras que estés vivo, claro, si tú mueres y estás casado, los hijos son del mismo matrimonio, la persona que sobrevive es encargada de los hijos. ¿Qué pasa si eres padre soltero, madre soltera? ¿A quién quieres que cuide a tus niños cuando algo te pasa a ti? hay una declaración para niños menores. All right, so I just summarized everything I said in English into Spanish. All right, how'd I do? ¿Hice bien? All right. I was that kid, like many of you here, that was picked by mom and dad to go translate. All right. Now, there's another way you can transfer assets outside of a will or trust. Hay otra manera de transferir bienes when you die. And those are called beneficiary designated assets. Puedes tener bienes que puedes transferir simplemente nombrando beneficiarios. So we know the most common one, a life insurance policy, right? You got a life insurance policy, and you name a beneficiary. You don't need to go to probate court. All you got to do, make sure you know you have a lot. Whoever named you as a beneficiary tells you. Of course, we've seen too many Dateline, 48 hours, or someone dies so they can get the insurance proceeds, right? But you just need to present a death certificate and establish the relationship to the person, and you'll get the life insurance proceeds. You don't have to go to probate to that. You don't have to go through a trust. Now, there's several different techniques. Some people like to put, the trustee of the trust to be the beneficiary of a life insurance policy. It just depends, right? And then here's one that's very important that I do recommend. Bank accounts. You can do what's called PODs, payable on death beneficiaries. So I had this situation happen in the last year with several clients of mine. They had a brother, and there's like 12 brothers and sisters, right? Guy was single, no wife, no kid. He was the only one in the bank account. Dies without a will, right? Now, he had a house, and I'll tell you later what we did on the house, but the bank account really would have to go get a court order to get to his bank account. Well, if he only has $1,000 or $2,000, by the time you pay filing fees and attorneys, it eats up that bank account, right? So everybody here, I would say, even if you have a cosigner account, say payable on death beneficiary, POD. All right, now I'll say that in Spanish. Si tiene una aseguranza de vida, claro, si tiene designado un beneficiario, eso evita el proceso de corte testamentaria. Si tienen cuentas bancarias, pueden designar un beneficiario en su cuenta bancaria. Tuve un caso donde un cliente mío tenía 12, 13 hermanos, murió sin testamento. Se tiene que conseguir una orden en la corte para tener acceso a esas cuentas. Y si nomás tienes $1,000, $2,000, ahí se te va el dinero en abogados y gastos de corte si no designas a un beneficiario. So I would say, please do a POD. Hagan un beneficiario en sus cuentas bancarias. Then, of course, if you have a 401k, IRA, retirement account, you can also designate a beneficiary. Now, retirement accounts are subject to ERISA federal law. So if you're married, you need to follow the rules on that. And then the other thing that can happen is if you get divorced, tip, si te divorcias, make sure you change your beneficiary. Si te divorcias, cambian tus beneficiarios, because if you die and they're on the retirement account as a beneficiary, guess what? Even divorce normally shuts off the beneficiary designation, but I don't think that applies to federal retirement plans. So make sure you do that. Then real property, believe it or not, real property. También en cuentas de bienes raíces or propiedades with real property, you can also do what we call beneficiary designations through something called a ladybird deed or a transfer on death deed. So I'll explain those. A ladybird deed is named the ladybird deed because First Lady Bird Johnson, President Lyndon Johnson's wife, used to transfer property this way. So this is how a ladybird deed works. I, Lady Bird D. Johnson, am the grantor of this property. I want to reserve a life estate. For the rest of my life, I reserve the use of this property. I have the right to cancel, revoke it, manage it, borrow against it. But when I die, my beneficiary is my daughter, let's say Linda Sue Johnson, right? So she dies. All you need at that point is an affidavit of death filed in the county records where the land is located, and that automatically transfers property to Linda Sue Johnson, right? That's a ladybird deed. Texas statute now allows something called transfer on death deeds, which is very similar, but that one is a form that says, I, Sal Espino, upon my death, my first beneficiary is my wife, alternate beneficiaries are my kids, and then when I die, to the first beneficiary, the wife, and then upon her passing to our children, right? That's a transfer on death deed. The difference is, on the ladybird deed, you reserve a life estate. A transfer on death deed, you don't, but then you also still have to file what's called an affidavit of death. And then the transfer on death deed doesn't have guarantees of title, which may or may not matter depending on your circumstance. All right, now I'll explain that in Spanish because it's kind of complicated. También hay una técnica para transferir propiedades, bienes raíces, a beneficiarios sin necesidad de un testamento o un fideicomiso. Se llaman escrituras en transferencia de fallecimiento y otra técnica que le dicen Lady Bird Deed, donde uno reserva el uso de la propiedad por toda su vida, pero al fallecer pasa al beneficiario designado. Al fallecer la persona, se pasa la propiedad a los beneficiarios con otro documento que se llama declaración de difunción o de muerte que se registra en el condado donde está la propiedad ubicada. Okay? So, then let's move on. Texas even allows you to designate beneficiary of your motor vehicles, right? And I think I brought the form. Let's see if I have it. También Texas permite que puedes designar beneficiarios de tu auto cuando mueres. I'm going to pass this form. And then when you pass away, the beneficiary named in that document files an application for title, and then that beneficiary gets the vehicle. También cuando tú mueres y designas al beneficiario con una aplicación de título para el carro y estás nombrado como beneficiario, recibes el vehículo, recibes el carro. So, as you can see, hay muchas oportunidades, mucha flexibilidad. There's a lot of flexibility with what we call beneficiary designated assets. Hay muchas técnicas, mucha flexibilidad en el uso de cómo designar beneficiarios de tus bienes. Now, let's talk about estate administration and other probate proceedings and what happens if you die without a will. Ahora vamos a hablar de administración de bienes, otros procedimientos en corte testamentaria y qué pasa si uno se muere sin testamento y no designas beneficiarios. Well, obviously, estate administration is the legal process by which you basically, someone gets control over your assets and then pays off your debts and distributes your property, right? That's the simplest form. In Spanish, we say legalizar. In English, we say probate. So you have a will, you probate the will. In español, legalizas el testamento. Once a will is probated, the court issues what are called letters testamentary to give your executor of your estate the legal authority to act upon, have the estate, collect your assets, pay your debts, and distribute the property. En la corte testamentaria, ya cuando se legaliza el testamento, la corte entonces autoriza el uso de cartas testamentarias donde el ejecutor de tus bienes colecta tus bienes, paga tus deudas y reparte los bienes como tú pusiste en el testamento. Right? Básicamente es el documento legal que le da la luz verde para seguir adelante. Basically, letters testament are the green light to move forward. So that's how estate, and it can take time. And the estate administration on a will, as I indicated earlier, can go from anywhere to 3 to 6 months, sometimes longer, depending on the complexity of your estate. Se tarda de 3 a 6 meses, a veces más, depende de qué tan complejo es tus bienes. Now, there are other probate proceedings, some that even allow the probate will as a muniment of title. Hay otros procedimientos testamentarios. So what is a probate will of muniment of title? Let's say all you have is really a house, maybe a bank account here and there. You don't have a whole lot, and you don't really have any debts except the lien on your house. So you can do something called probate of will as muniment of title. It's a fancy term that says, honorable court, take my will, probate it, and then all I have is this house. It doesn't have a debt, or it does have a loan, but I don't have anything else. And what that does, you don't even have to appoint an executor. You don't have to wait 6, 9 months, 3 months. It can be done like that. So that is an easy way to probate a will. Immuniment is a fancy legal term to say evidence of title, right? But that's an easy way to do it. So, ahora en español. Se puede legalizar un testamento como evidencia de título. Si nomás tienes tu casa y nomás tienes la hipoteca sobre la casa y no tienes otras deudas y no hay necesidad de seleccionar a un ejecutor de tus bienes. Simplemente vas a la corte, aquí tengo ese testamento, no tengo mucho, no necesitamos que hacer una administración formal y nomás necesito que este testamento se legalice como comprobante de título. Then, once that is done, the order and the application of probate the will is filed in the real property records of the county where the real property is located, and guess what? You transfer title to the property. All right? So, ya cuando la corte firma la orden aprobando ese testamento, se registra la orden, la solicitud, en el registro del condado donde está ubicada los bienes raíces. All right. Then, what if you die with a will, but you don't have much? You do what is called a small estate affidavit, and it has to be $75,000 or less of your assets. That does not include your homestead, your house. That is excluded, or Texas exempt property. So it's $75,000 without including your home. Let's say you have a $150,000 house and you die. That is not included in figuring out the $75,000. Also, what Texas calls exempt property, which I'm not going to get into too much, but the exemption for exempt property is $50,000. I believe it's $100,000 for married people. And so you can do a small estate affidavit. That's typically what we have to do when people die without a will and they only have like a bank account or a car, right? And that's what we do. So, declaración de bienes pequeños es $75,000 o menos. Eso no incluye tu casa, tu vivienda, tu residencia personal, no se incluye en eso. Y lo que Texas también tiene, que le llaman propiedad exenta, que en Texas para una persona soltera $50,000, para una persona casada $100,000. Y eso es lo que utilizamos, como si alguien se muere sin testamento y hay una cuenta bancaria donde no nombró beneficiarios, usamos esta técnica, right? So that small estate affidavit is used. Then, however, if you die without a will, this is where it gets expensive and you have a lot of assets. Si te mueres sin testamento y tienes muchos bienes, entonces aquí es donde se pone un poco caro. There's something in Texas called the termination of heirship proceeding. Court, tell us who the heirs are. And then the court appoint an administrator. Court, have that administrator collect the debts, collect the assets, pay off the debts, and distribute the property. That can get expensive. So you want to avoid that determination of heirship proceeding because you can spend a lot of money if you didn't do a will, you didn't do a trust, you didn't take care of your assets while you're alive, because that can get problematic, right? So, hay otro procedimiento legal, determinación de herederos, donde mueres sin testamento, no hiciste un fideicomiso, no nombraste beneficiarios, tienes que ir a corte y la corte tiene que determinar quiénes son los herederos, se nombra un ejecutor o administrador, se colectan los bienes, se pagan las deudas y se reparte. Ahí sí puedes gastar bastante dinero en abogados y en gastos de corte. All right? So, let's assume you die without a will. What does Texas law says on intestacy? Who gets your property? Just basic, what we call Texas law of descent and distribution. Well, basically in Texas, and this is after 1993 because they changed the law in September 1993, if you die without a will and you're married, and all of the children are the same marriage, remember Texas is a community property state. So husband and wife. Wife is here, husband here, all the children same marriage. Husband dies. Because the children are all the same marriage, his 50% of the community property passes to the surviving spouse, or vice versa. As long as the children are all the same marriage. Here's one of your problems. Let's say husband or wife has children by other marriages. Well, wife or surviving spouse gets 50%, but the other 50% doesn't go to the surviving spouse if their children outside the marriage. The other 50% goes to all the children of the spouse that just died. And sometimes children from other marriages may not like your current spouse. So there you probably need a trust or a will or a transfer on death deed to make sure that your spouse gets the other 50%. Because if you haven't seen Johnny in 20 years, or your children by prior marriages don't really have a relationship with you, they could become owners in this house you have with your new spouse. So remember that, right? All right, then what happens if you die and then you have, you're not married, you're single. All right, so if you're single or you have no children, obviously, then it goes up to your parents. If mom is dead or dad is dead, 50% goes to the surviving parent, the other 50% to your siblings. All right, if mom and dad are not here, then it goes to your siblings, your brothers and sisters. If you don't have brothers and sisters, then it goes to their children. I mean, everybody thinks the state's going to get it, but the state's only going to get it if you really don't have any family, and even then it's a long process, right? So ahora en español, si yo estoy casado y me muero sin testamento y todos los niños, hijos son del mismo matrimonio, Texas es un estado de bienes comunitarios, el 50% del esposo que muere o esposa pasa al que sobrevive porque todos los hijos son del mismo matrimonio. El problema es si tienes hijos de diferentes matrimonios. Si mueres y tienes hijos de diferentes matrimonios, tu 50% no pasa a tu esposo o esposa que te sobrevive, pasa a todos los hijos que tienes de todos los matrimonios. Y a veces los hijos de otros matrimonios no quieren a tu esposo o esposa que ahora tienes. So, ahí sí necesitas un testamento, un fideicomiso, o una escritura que transfiere todo a tu esposo o esposa. Y ahora, si te mueres, no estás casado, pasa a tus padres. Si uno de tus padres ha muerto, 50% del padre o madre que sobrevive, el otro 50% de tus hermanos. No hay padre y madre, todo en partes iguales a tus hermanos o hermanas. Y luego después, si no hay hermanos o hermanas, a los hijos de tus hermanos. Es muy difícil que el Estado consiga tu propiedad si tienes familia. All right, now, Texas has a real streamlined procedure. Let's say this happens a lot in real estate. And title companies and attorneys use something called affidavits of heirship. You die without a will. The main asset that the person that died was a house. Title companies accept, and Texas law allows what are called affidavits of heirship. What is an affidavit of heirship? Title companies like it this way. A family member, usually the surviving spouse or a child, says, I knew the decedent, I knew the person that died. He was married to so-and-so. They had the following children who were born in such and such dates. They live in such and such dates. There was no will. he owned an interest in this following property. So the affidavit of heirship basically outlines the family history of the person that died, and then title companies use that in attorneys to determine who the heirs are. And then, let's say if it's mom and dad dies without a will, and all the children say marriage, and then that would vest title in the mother, and then the mother could then sell the property by the filing of an affidavit of heirship, right? Now, that can be tricky, because in the old days, people had 13, 14 children. Just recently, I had someone come to my office. The father died without a will, 21 children. All right, so we're going to do an affidavit of heirship, but in order to sell that property, and you know, the wife is, and this guy I think was widowed, all 21 children have to sign the deed to sell the property, and the sales price has to be divided 21 ways, all right? So now en español, si uno muere sin testamento y el más grande viene es la casa, bienes raíces, las compañías de título y el Estado de Texas permite lo que le llaman declaración de herederos, declaración de herederas. Un familiar, probablemente la esposa que sobrevive, un hijo y dos testigos interesados, dicen, este es mi esposo, se murió en tal fecha, tuvimos a estos hijos y esa propiedad. Eso entonces pone la historia de herederos, de hijos en el registro público. Entonces las casas de título permiten que las personas que son los herederos reciban esa propiedad cuando se venda. So, si es la esposa que sobrevive la esposa y todos los hijos son del mismo matrimonio, eso en efecto permite que la esposa o esposo que sobrevive pueda vender la propiedad. Recientemente tuve un caso donde un señor se murió y tuvo 21 hijos. Entonces ahora para vender esa propiedad, los 21 hijos tienen que firmar esa escritura. Así que hay que hacer un testamento, si tiene una familia grande, un fideicomiso, otras técnicas para transferir títulos de escrituras. So now the final is tax considerations and issues. Texas does not have a state inheritance tax or a state tax. If you die, your heirs will not have to pay, your state will not have to pay a state inheritance tax or a state tax in Texas. Texas no tiene impuesto de herencia estatal, okay? They call it the death tax, el impuesto de muerte. At the federal level, only if you're super rich, right? There's a federal tax exemption of $13.99 million for individuals. So if your state is bigger than $13.99 million, you may pay federal estate tax, right? Al nivel federal, solo si tus bienes valen más de 3.99 millones de dólares, vas a pagar el impuesto de los bienes al gobierno federal. Now, if you have a trust, and it's let's say a living trust, what they call a revocable living trust, the grantor still controls it. You still control the trust. The income of that trust then is taxed on that individual income tax return, your Form 1040, more or less, right? Si tienes un fideicomiso y tú eres el que lo controlas, el ingreso de ese fideicomiso, ese trust, se reporta en tu declaración individual de income tax, de impuesto federal. In all other cases, you have a different kind of trust. If the beneficiaries receive income from the trust then does a Form 1041 tax return for a trust, and they have what they call Schedule K-1s, and then the trustees report their share of the trust income on their personal income tax return of the money they get from the trust. Si tienes un fideicomiso y se reparte ingreso a los beneficiarios, hay un formulario 1041 y el formulario K1, y los beneficiarios reportan su ingreso en el income tax personal de la parte del ingreso del trust que les pertenece a ellos. If the trust keeps the income and doesn't distribute, they have to pay the income tax on Form 1041. Si el fideicomiso no reparte o 100% del ingreso, entonces el trust paga el income tax en el formulario 1041. And the last thing I'll say is when you inherit property, two things. It's separate property. Cuando heredes una propiedad, son bienes separados under Texas law. Número dos, when you inherit property, let's say your mom and dad bought a house here in Worth Heights back in the day when real estate was cheap, when it was maybe, $20,000 for a lot. Today, that same property is probably worth now $200,000. Mom dies, you inherit the property. You want to sell it. All right, so you sell it right away. You don't pay income tax on the 200 versus the 20. Since you inherited at 200,000 and you sell it at 200,000, you get the benefit of that stepped up basis and you're not taxed on that for income tax purposes. All right? Ahora en español, cuando mueres y recibes propiedad de herencia, primero son bienes separados. So unless you want to add your spouse to the deed, you can always do a gift to a spouse and add your spouse to the deed if you want to, right? But you don't have to. Then the other thing is this. You get esta cosa, cuando recibes esa propiedad, tu mamá y papá la compraron cuando nomás valía $20,000. Cuando mueren vale $200,000. Tú la vendes a $200,000. No pagas income tax en la diferencia entre $200,000 y $20,000 porque tú la recibiste a $200,000. Ese es el basis que se usa. No pagas income tax. No hay gane. Okay? So in a nutshell, as you can see, estate planning can be pretty complex. Every situation is unique. Do you need a will? Do you need a trust? Do you need both? Do you want to do where you designate beneficiaries? Can you avoid probate altogether? Is that wise? So I would advise you to consult with an attorney as to your individual needs and your individual situations. Le digo que consulten con un abogado para su situación particular. ¿Necesito un testamento, de comiso o los dos? ¿O puedo designar beneficiarios? ¿O necesito que hacer un testamento? So, gracias. Thank you so much. And if you have any questions, we'll take them. Gracias. Thank you.
So the first one is a trust a one-time cost or a monthly cost until time of death? And about how much do you save doing the trust compared to all of the costs at the end if you wait?
Well, to set up the trust, it's just a one-time cost. When I say ongoing administration, it's if you ever want to change the trustee or make changes to your trust, there's a cost there. But to create a trust, it's a one-time upfront fee, right? And then if you don't change it, and leave it the way it is, then there's no additional cost. Now, you have to fund the trust. Funding means transferring property into the trust. And what I recommend, if you have real property, then you do the deed one time, right? Now, if you add more property to the trust, each time you do a deed, there's a cost. And so, yes, to set up a trust, there's a one-time fee along with transferring assets. But then if you don't do anything else the rest of your life to the trust, leave it the way it is, there's no additional cost. If you're specifically, if it's a living revocable trust, right? If it's a revocable living trust and you control it, unless you add more stuff to it, then there might be some additional costs. Oh, let me translate in Spanish. ¿Hay un gasto de un fideicomiso es un gasto de una vez o hay más gastos? Establecer el trust es un gasto inicial, ¿verdad? Si no pones más propiedad en el trust, en el fideicomiso, no hay otros gastos. Pero cada vez que añades propiedad o haces cambios, sí va a haber un gasto.
Okay. The next one, can I use a transfer on death if there is a reverse mortgage on my home? And that also is a question for vehicles. Does it have to be paid off in order for the survivors to get the vehicle?
Well, on the vehicle, it's an easy one, no, but then, you got to pay off that note or keep making payments or else they'll repossess the car, right? So, con carros, si designa un beneficiario se debe una deuda, claro, recibes el carro, pero sujeto a la deuda. Si no pagas los biles del carro, te quitan el carro, reposición. As far as reverse mortgage, the way those work, first of all, if you get in a reverse mortgage situation, those are somewhat challenging. There, the way that works is you get money, builds up the mortgage balance, and then when you die, the property is sold to pay off the mortgage. So that would be tricky to see how you can get out of that obligation because basically at that point, unless the property has more equity than the mortgage, it might be an issue. So we'd have to come see me about that and explore that option. Let me say it in Spanish. Hay propiedades que están sujetas a una hipoteca irreversible donde me dan dinero, pero sigue aumentando la deuda, la hipoteca de la casa, y típicamente tiene una provisión de cuando se vende la propiedad, se paga la hipoteca. Se puede usar una escritura de transferencia en caso de fallecimiento. Depende si la propiedad tiene lo que llaman equidad, que la propiedad vale más que la deuda. Tienen que ir a verme para ver más bien la situación. Okay.
My parents sold me the house, but the lawyer said that Medicaid could still take it. What do they mean?
All right, so the federal government has something called MERP, the Medicaid Estate Recovery Program. What that means is if you did not live in the house with the person who transferred the house to you or sold it to you, and they died within the last 5 years, there's a 5-year look back where the federal government has the right to recover their cost, right? It's called MERP. There are ways to avoid that. One of the ways to avoid that is the use of a ladybird deed, which says, I reserve this property for the rest of my life, but when I die, it goes to this person. Well, when you die, that is not part of your estate, so the federal government can't get that property because you basically, at your estate, it's gone. It's automatically transfers to the beneficiary. So Medicaid does allow the use of ladybird deeds to avoid that situation, and then Medicaid also has several exemptions, like if you lived in the household and you were the primary caregiver for that person. So it's Medicaid, just so we're clear, is the federal insurance program for folks that are moderate income. Medicare is the healthcare program for seniors, right? 65 and over. But Medicaid does have a recovery program. So now I'm saying in Spanish. El programa de Medicaid, que es el programa de seguridad para personas con recursos modestos, es diferente que el programa de Medicare, que es el programa de salud para personas de edad mayor. El gobierno federal tiene un programa de recuperar gastos de Medicaid, así que si mueres y recibes Medicaid, pero has vendido una propiedad o has hecho transferencias, el gobierno federal puede buscar recuperación de sus gastos. Hay una técnica con el uso de esta escritura Lady Bird que dices, yo mantengo luz esta propiedad por el resto de mi vida, pero al morir pasa esta persona. Cuando mueres no es parte de tus estate, de tus bienes, y el gobierno federal entonces no puede conseguir esa propiedad. So yeah, Medicaid is very important. What I advise clients is you can use a ladybird deed to avoid that from happening to you.
Thank you. I used a professional executor service for senior concepts. This executor said he didn't want any info about my financial situation. He said he would find out after my death. He didn't want any info from me. And is this how a good executor should work, or should I do something else because he's now in charge of my will?
Well, an independent executor is a person that you designate in your will to obviously, take the will, get probated, and be named as the person who's going to manage your assets and your debts when you pass away and distribute your assets. Yeah, that is not. You should go see an attorney. You should always know what your assets are. The independent executor doesn't necessarily have to know your financial affairs, but that doesn't sound like a good situation. So I would advise that person to go see an attorney. Mi ejecutor de mi testamento dice que no necesita que saber nada de mí, que después cuando yo muera va a saber todo. Yo le dije que vaya con un abogado, que normalmente no es necesario que un ejecutor determine todo eso, pero es bueno tener a alguien de confianza y es mejor que hable con un abogado.
This one's about motor vehicles. Does a form need to be filed somewhere prior to death, or is this turned in after death? And if you die without a will, how long after death can a beneficiary claim property?
Well, I mean, okay, so first, the beneficiary form can be filed at any time before death, right? Esa designación de beneficiario para vehículo lo puede uno enviar al departamento de vehículos cuando quiera. The thing is, when you die, then that person then has to do the application for title, right? Cuando uno muere, entonces tiene que hacer la solicitud para la aplicación de título del carro. As far as how long, to probate a will in Texas, they give you 4 years, right? Te dan 4 años para legalizar un testamento. You can do it after 4 years, but then you have to show good cause why you didn't file the will within 4 years. So it's a good rule of thumb to use 4 years. Now, the state of Texas, does eventually get unclaimed property, and I don't know what the rules are on unclaimed property, but yeah, usually a good rule of thumb is 4 years. Para legalizar un testamento, tienes 4 años de la que la persona muere. Si te tardas más de 4 años para legalizar un testamento, tienes que demostrar buena causa por qué no legalizaste el testamento en 4 años. El estado de Texas, no sé cuáles son los reglamentos de qué tanto tiempo tienes antes de que ellos tratan de tomar propiedad, but I would say 4 años es una buena regla.
My mother has 4 children. What is your recommendation to her if she does not want to leave her house to just one child? Would this be a simple will? And what happens if you have children you don't know about and they claim after death of parent?
Well, that is the danger if you die without a will, right? If you die without a will and you have 4 children, but let's say 20 years ago you were in Mexico and something happened, right? And you may have a child there. Well, if you die without a will, if that's your biological child, under the laws of inheritance here in Texas, they may have a claim on your estate. So a will is a good option, or you could do what I call transfer on death deed or ladybird deed, where you say to these 4 children in equal shares, right? Or in the will, to these 4 children only in equal shares. So that's how you would deal with that situation. Now in Spanish, dice, ¿qué es lo mejor si tengo 4 hijos y a lo mejor hay un hijo que no sé dónde está, o si tengo otro hijo por ahí? En ese caso, si tienes hijos y hay uno que no sabes, pero aparece y no tienes testamento, todos tus hijos tienen reclamo contra tus bienes. Así que necesita un testamento donde dice solo a estos 4 hijos en partes iguales, o una escritura en transferencia de muerte, o Lady Birdie que dice a estos 4 hijos solamente en partes iguales. Okay.
All right, we've got 2 more. If a primary residence has homestead exemption and property is transferred to a trust, how is the homestead exemption affected?
Well, if you transfer it to a trust, you have to have a provision in the trust that says this specific property used by the trustor or a beneficiary is my homestead. You can't charge that person rent. They can, so you have to have a provision in the trust that says that this property is the homestead, and then that is allowed under the Texas tax code. And my TAD expert here can elaborate on that further. En Texas, si transfieres propiedad a un fideicomiso y en el instrumento del fideicomiso dice que esa es su residencia principal, tu homestead, y no cobras renta, todavía tienen que pagar los taxes, claro, todavía puedes tener la exempción de homestead.
When a person dies and the house is in their name, does the husband have to put it in his name, or can it stay that way, or put it in his kids' names?
Well, when you die without a will, automatically the heirs, are the owners, but to legally change it, and this is where you could probably go to an attorney or a title company, you can do what's called an heirship affidavit, and then if all the children are the same marriage, it passes to the surviving spouse, right? But if there are children by different marriages, especially if this other spouse died and had children, then it goes to all the children of all the marriages. So, yeah, just because you died, that doesn't, when you go take the tax account, you can call Tad in the tax assessor collector office, hey, put me as the sole person on the account. That legally does not change the status of title. You still have to do a couple more steps. So I would at least recommend talking to an attorney, maybe at least doing an heirship affidavit if you die without a will and all the children of the same marriage, to at least put everything under you. Si muero sin testamento y cómo pasa título a mí, y le digo que la mejor opción es una declaración de herederos. Si todos los hijos son del mismo matrimonio, entonces eso, las casas de título aceptan eso y abogados para que la casa esté a nombre del esposo o esposa que sobrevive si todos los hijos son del mismo matrimonio. Okay.
Thank you for answering our questions. Does anybody else have anything, any last comments you'd like to make or concerns? Okay, I'm going to give it over to Ms. Vicky.
Thank you for your patience. Very good questions. Thank you for indulging me. Gracias.
Thank you very much, Sal. You gave us so much great information. Again, we have with us Mr. Joe Don Bobbitt, who is the Chief Appraiser for TAD, and he can answer any questions that you have regarding property taxes. We have some brochures at the front over there on that front table where you signed in. And there's a QR code on the back that you can access our very first workshop that we had, which is very informative. Mr. Bobbitt participated in that, and so did Chandler Crouch, who has helped many residents with their property taxes. So, Joe Don?
My name is Joe Don Bobbitt. I'm the Chief Appraiser for Tarrant Appraisal District. So we want to go over some of the common residential exemptions. It's one of the main things that you want to make sure that you have. You want to make sure you have all your exemptions that you're entitled to. The most common ones are the homestead exemption, over 65, disabled person, or disabled veterans, and there are a couple different types of disabled veteran exemptions. For homestead, all the requirement is you have to own the property. It has to be your primary residence. You can have no other homestead claimed, even in other states. It has to be your only primary residence. You must provide a copy of your state identification. So we just need a Texas ID. It doesn't have to be a driver's license, but it has to be a state ID from Texas. And we do need a copy of that. On April 30th, there's the application deadline. So if you're going to apply for a given year, you're supposed to give it to us by April 30th. We can go back 2 years, though, so it's an extremely soft deadline. So if you realize that your exemption is missing from your appraisal notice or from our website, give us a call, come in and see us, because we can go back and put it on for 2 years, as long as it was your primary residence 2 years ago. For over 65 or disabled person, oh, well, hold on. Right now, the homestead exemption offers $100,000 off of your school tax. So whatever the value is on your property, so if we determine your house is worth $200,000, we take off $100,000 for the school, then multiply that by the tax rate. It's optional for the other entities. So for the county, the junior college, the hospital district, if they offer an exemption for homestead, it's optional. They don't have to do that. The legislature is also looking at bumping this to $140,000 this year. And so we expect that to pass. It has to go to voters in November, and we expect that to pass there again also. For over 65 or disabled person, it's an additional $10,000 in value reduction from your appraised value for the school district. It also enables a freeze or a tax ceiling. So once we determine what your tax rate is, or your actual tax amount that you pay in a given year with the exemptions in place, that amount that you actually pay, so if you're giving the school district $300, that's your ceiling. And so that what you pay in future years can go below that, but it won't ever go above that. It doesn't freeze the tax rate, and it doesn't freeze the value. It freezes the actual dollars that you paid to the school. For the requirements, it's the same as the homestead, plus you must be 65 years old at any point during the year. So if you turn 65 on December 31st, you qualify for an over 65 the entire year. You have to meet the definition of disabled for the purpose of disability insurance payments. That's to get the, for over 65. An eligible disabled person, age 65 or older, may not receive both exemptions. So if you're over 65 and disabled, you don't get $20,000 off. You get one or the other. You have to pick. You can't combine them or add them together. If you're disabled and then you turn 65, usually we'll convert that into an over 65 exemption because usually more entities will offer that. They'll have that optional exemption. If you do add a new building, if you add something to your property, that's the only time your freeze will actually get disturbed and can go up. So if you add a building, you add a pool, a new garage, an extra 1,200 square feet to your house, then we'll recalculate the ceiling and add that new value to that ceiling. But it won't reset it completely. It just adds the new tax for that new structure. And if you're over 65 and you pass away, if your spouse is over 55, then they get to keep your exemption. There's a surviving spouse exemption. But if it's a May December kind of thing where you're over 65 but your spouse is 40, she does not get, or your spouse, whoever it is, male or female, would not get the benefit of your over 65. For disabled veterans, there's 4 different steps, and so we need a letter from the Veterans Administration showing what your level of disability is. And so if you're between 10 and 29% disabled, you get $5,000 exemption from your property. Between 30 and 49%, it's a $7,500 exemption. Between 50 and 69, it's up to $10,000. And 70 to 100% is up to $12,000. There's also a 100% disabled veteran homestead exemption. So if the VA says you are completely disabled and unemployable, then you pay no property tax to any of the entities. There's also another one for donated residents and surviving spouse. So if you're just completely 100% disabled veteran and you pass away, your spouse would not have to pay going forward. We have a new online application system. And so if you're missing your exemption, you can come on here and apply, upload your driver's license, and you'll get a quicker turnaround and notification if you're granted the exemption. And if we have an issue with you with the exemption, we'll reach out and ask for additional clarification or documentation. We typically do not respond and tell you that it's granted, but we will tell you if there's a problem with it. On the homestead reapplication, you do not need to reapply every 5 years. But if we mail you a letter, you need to respond to it. So if we mail you a letter saying you need to reapply, then you need to reply, because otherwise we will remove it. But you don't need to just automatically remember to reapply every year, every 5 years. Right now, we have a new system that will flag your property if there's a potential issue with it. So if you have a mailing address change, if you have voter registration or vehicle registration showing that you moved someplace else or that you might potentially live in another state, we can flag that and we'll ask you to reapply. Unclaimed homesteads, the system that we have will now find if you live there and all your mail goes there and everything indicates that you actually reside in that property but you're not currently receiving a homestead, we're going to mail you a letter. We're going to mail you a letter every year saying please reapply for the homestead if you don't already have it. And it also allows us to find them and process them faster. Part of this, we want you to have your exemptions. We're not trying to remove them from anybody that's actually entitled. So we want you to apply for it. We want you to get it. On a tax deferral, a lot of times we hear complaints in my office that we're trying to take your houses from you. That's not the case. If you're over 65 or disabled, we're barred from doing this. But if you fill out a tax deferral with my office, it prevents the attorneys from going down that path of, if you get behind on tax payments. And so it defers the collection of a tax and it abates the sale. So that way the tax office will not foreclose and will not take your home. It has to be on your homestead, and it only applies to if you're over 65 or disabled person. So if you're under 65 and you get behind in your taxes, the tax office could take it, but they typically don't. This has to be filed with my office. So even though this is a tax office function, we have to be filed with my office. That way we know about it, and then we will relay that information to the tax office. It still does incur interest at 5% per year, but you don't get a penalty. So it's just 5% interest, which right now may be better than most bank loans. So it may not be a bad way to go. One of the issues that you have to look at, a lot of times, if you're over 65 and people get the tax deferral, they may do that intentionally. Some elderly people may do that on purpose, realize they cannot afford their taxes. And so you can go on for 20 years or more accruing interest and accruing the taxes. But sometimes they forget to tell their children. And so the children are thinking that they're going to inherit that property, and then they come to find out when their parents pass away that there's 10 to 20 years of back taxes on it, and then at that point it's going to get foreclosed and sold unless the children can come up with the money to pay off the tax. And you have 181 days after the person passes away to catch up on the taxes. So that's what I have really quickly that gets into this estate planning, but I'm more than happy to answer some questions. Yes, ma'am?
I've got two questions. My mom's property value notice reflected an increase in value. I thought appraisals are only for every 2 years now. No change to ownership of the home.
It's two different parts. And so what my office determines is the market value. So we determine what we think the house would sell for, and that is what is on the 2-year cycle. But there's also an appraised value. And so whenever the market increases more than 10% per year on a homestead, we're not allowed to tax that increase above 10%. So there's an appraised value, which includes that 10% limitation. So the appraised value and the market value will become different. And so the appraised value can only increase 10% per year. And so if there's a gap, that value is automatically going to increase 10% until it catches up to market. And so even though we didn't change the market, the appraised will automatically go up until they meet and equal. The appraised cannot exceed market, though.
This is about a disabled exemption. What happens if you get behind on taxes with a disabled exemption? What happens to the amount owed?
You need to file a tax deferral, and then that you would quit getting the penalty on it, but you'd still accrue 5% interest. And so that would accrue until you're able to pay it off. But it also allows you could pay whatever amount you can whenever you can pay it. So even if you can't pay it on the quarterly payment schedule, you could pay monthly or just whenever you can, and then you cut down on the interest that you owe, and you could pay it, even if it's make monthly payments, you just accrue interest at that point.
And there have been individual accounts of homesteads no longer showing on tax papers. What causes this, and how can it be avoided by the homeowners?
It could be that we've mailed them a homestead application in the past and they didn't respond, or that we had other indicators showing that they did not live there anymore. And so usually if we see that, before we remove it, we'll send them a letter saying that they need to reapply. And if they don't respond, then we're going to remove that letter. For over 65 disabled persons, we're going to mail you a whole lot of letters. We're going to mail you a normal first-class mail letter, and then we're going to mail you a certified letter, then we're going to mail you another first-class letter, then we're going to mail you another certified letter before we actually remove that exemption. So we're going to reach out to you multiple times to try to get you to respond to the homestead exemptions.
Who do we contact when Linebarger misinforms Spanish-speaking residents of unfair fees and demands?
That I'm not sure. I mean, that is a law firm, but then they specialize in tax collections. There are other law firms, but they typically work for the taxing entities, and so I'm not sure who you would reach out to. There are some attorneys that deal with property tax, but they work for tax agents and for property owners. But I don't typically use those guys. I don't deal with them that much.
I have one more that I just thought of. Is there translators available at the tax office when people go down there, or do they need to request it beforehand, or is that not an option once they're contesting taxes?
We have Spanish-speaking individuals at our office, and that will help you. If it goes before a hearing, we may need you to let us know ahead of time, so that way we can make sure that we have somebody available. Or you may, if you want to bring somebody, you're always welcome to bring somebody that can translate for you.
But there's no designated translator.
We have staff available that can speak Spanish.
I have a question. Earlier, I talked about what they call contract of sale, contract for deeds, or rent to own, which is an arrangement where I'm buying property, but I don't get title till I make all the payments, even though I live in the house as my residence, but I don't get title to the end. Am I eligible for the homestead exemption?
If it's contract for deed, we'll need to see the deed. If it's recorded, then potentially. If it's not recorded, then we wouldn't reflect that. If we're confused about it, we're going to send it to our attorneys and have them review it and let our attorney tell us that we can put it in the owner's name or the buyer's name. But it's not automatic.
Thank you.
Okay.
Thank you, everyone. Thank you for hanging in there through the end. There's a lot of great information that was given to you. My name is Marcela Nava. I'm with UT Arlington School of Social Work and a neighborhood resident. And I get to have the pleasure of helping to draw the raffle. So does everybody have their raffle ticket? Can you hold up your raffle ticket? Make sure you've got one. If you're missing one, make sure to let Miss Vicky in the back know so you got one. Everybody have their raffle ticket? Okay. All right, and I just want to point out we've got 2 amazing baskets back there from Dos Hermanos Farmers Market that just opened up. There's some flyers in the back, so make sure to pick one up and drop by. They're located at 3247 Bryan Avenue. And we also have a donation of a speaker from Ms. Rosemary with the Worth Heights Neighborhood Association. So we've got 3 prizes. Tenemos 3 premios para recibir 2 canastas de comida para los que no vieron los volantes de los Dos Hermanos Farmers Market y también una bocina donada por Rosemary de la Asociación de Worth Heights. All right, so let's start. I'll start with the speaker and we'll work our way up. Okay. All right, first one is ticket 6809512. 6809512. All right. Yay. You got it. Yeah, thanks. Okay. All right, now for one of the baskets in the back, para una de las canastas. This is going to be 6809517. Termina con 9517. 6809517. Going once. 9517 going twice. Okay. 9513. 9513. 9513. Okay. 9515. 9515. Woo! Oh, you were 513? Oh. Okay, well, you got 95. Okay, and we've got 9515 over here. Okay? All right, that's all 3 of them. Thank you. Thank you so much. Do we want to have some final words from Ms. Vicky to close us out?
Well, once again, thank you very much for coming, and a great big thank you to Sal Espino, to J.D. Bobbitt. We really appreciate their coming, imparting their knowledge. I mean, this is something that's very important for everyone, and we hope that we're going to try to do this again, perhaps in the fall. So we would like to know as well what you think and what else you would like to see us present to you. You can write your suggestions on a card and turn it in to the back over there to Angie or Marcella, and we're going to work on that. But this is information, something that you can use all the time, and you don't get it all in one sitting, so I can still think of a dozen questions I could ask. Anyway, thanks again for coming, and we'll do it again. Thank you.